at this point if you're planning on being in the lottery this year. And we're also going to talk about red flags at the consulate. Every day we're hearing from people who are getting a 221G at the consulate, getting visa denied, even getting lifetime bans for misrepresentation in part of their immigration process. So we'll talk about what to be careful of there so that you don't fall into those same situations. And navigating a layoff with your H-1B. Those layoffs are still happening all over the place. What are we seeing in terms of the grace period now? When does it start? What do you need to do if your grace period is ending? What options do you have? And lastly, remote work. How does that work with immigration? It was a big topic during COVID, and a lot of people are still working remotely. What do you have to take care of to make sure that you are in compliance and that your company is in compliance if you are working remotely?
Emily, the first point with regards to the fiscal year 2025, although it starts on October 1st, but we can file the application in April, and we have to do the lottery system in the month of March, probably in the first week of March, probably ending by the 20th of March is normally it's been there. And the instructions do come in February, though, every time. The how to register, how to apply, all the instructions come in February. Right now, you told some news that it's going to be different than last year, because previously, if 10 companies used to file an H-1B for a single candidate, let's say Srinivas Rao, and then they do select that the guy will be counted 10 times. But now, the new indication from USCIS is that they're going to count Srinivas Rao as only one candidate, and then have him choose which company he wants to go. What is the difference? They are doing it online. How do people need to prepare? What are the steps that, you've been doing this lottery system from 2007 onwards? That's when the lottery system began exactly. And right now we are in 2024, 2024. So it's approximately how many? Like 17 years?
Too long.
Yeah, too long. I don't want to disclose your age, but yeah. So what are the steps people need to take care of? What are the things where you see the last minute people are unable to get in for technical reasons, or they get in with the wrong company? Can you explain what, if I don't have a H-1B, I want to get a H-1B, I want to go in the lottery system, what are the steps that need to be done?
First thing is start talking to your company now. So we're assuming that you are in the U.S. already employed either on OPT or CPT or H-4 EAD, L-2, whatever, L-1B. Now is the time to start having those conversations with your company to make sure that they do intend to register for you, because they need to make sure that the company's account is set up. That typically happens towards the end of February when they open up that system. Then you need to make sure that you are prepared. So for that, we don't need a ton of documents or information in order to actually submit the registration under the current system. We literally just need your passport. And if you're planning on submitting in the master's cap, then we typically ask for a copy of your degree certificate or transcript so we can verify that the school you went to does in fact qualify for the master's cap, because not every U.S. master's degree qualifies in the master's cap. So that's all you need to gather. Other than that, it's making sure, again, if you are working for the company, you're comfortable with the company, you feel like they are doing things correctly and following the rules, register with your company. If you are looking elsewhere for a company that maybe you're not employed with yet, you really need to be careful here, because we saw last year, and we've seen it prior years too, and we've tried to warn people so many times not to go with these companies that you have no relationship with, who sometimes might be asking you to pay fees in order for them to register you. Those companies ended up filing 400,000 registrations for people, all of them duplicates. None of them filed the petitions because USCIS finally came out and said, we're going to be referring these people for criminal prosecution. So you need to stay away from that. Stay away from companies that are saying they have an in-house project for you. They'll find a job for you after you're selected and after they file the petition. Ask around about the company. Check them out on LinkedIn. Check them out on My Visa Jobs. Make sure that they're filing things properly. so that you don't end up with a fraud or misrepresentation on your name, because we saw that last year when USCIS sends a notice of intent to deny or revoke for fraud. They're blaming the beneficiary too, and we're seeing beneficiaries having trouble. Future visa applications at the consulate, future extensions or transfers with other employers. So you have to be very careful in your selection of employer.
So, Emily, what are the things, what are the deadlines? So, for example, when do they have to file? When does the company has to register? When do the company has to apply for the lottery? When do the results of the lottery will come in?
So, assuming the system is similar to last year, typically towards the middle or end of February, USCIS will open up the company accounts. The company has to have a My USCIS account, and they have to create that account as a registrant. It's a very specific account. So they might already have a My USCIS account, but it might not be the right type of company account for that. So they need to make sure they have access to it. Sometimes if the contact person over the company or the signing person has changed, they may no longer have access. They might not have the two-factor phone number. They might not have the password. So they need to get their account taken care of in the month of February. The actual registration window typically happens in the last 2 weeks of March. Mid-March it should open. And we typically get 2 weeks for that. That's relatively easy. It's just a lot of data, manual data entry. We don't submit any documents. Usually that window will close, and then on about March 31st, we start getting notifications from USCIS that they've run the lottery and you have selection notices in your account. We then log in. The company can also log into their account and see them, but we can see those selection notices. We notify the company, ask them if they're ready to file, and then we actually prepare the petition for filing between April 1st and June 30th. If you are on OPT and planning to use your cap gap to extend your OPT based on the filing of the H-1B, make sure your H-1B gets filed by the time your OPT expires, even if you technically have until June 30th to file the petition. But all that to say, this year might be completely different. USCIS just announced last week this new online filing system specifically for I-129s that are specifically going to do it for this cap season. And it sounds like they're also going to use it for the lottery itself. So it might be completely different. We don't know what it's going to look like. We should find out some additional information next week. I think they're hosting some stakeholder calls on that. So it could be completely new, or it could be the same system that now just allows us to file the petition. But as far as the duplicate filings with people going with the multiple companies, only having one actual selection they can use, I don't know if that's going to be implemented in time, because that's regulatory process. That's part of that big H-1B regulation change they want to do that's still under consideration, and they have not published anything in the Federal Register saying they're going to implement that. And I don't know if there's enough time for them to publish it now for it to take effect in March when this happens. So we may still have duplicate problem and that fraud problem like before, but hopefully people learned their lesson and aren't going to do that this year.
Consulate's red flags. So now there have been a lot of 221Gs, a lot of misrepresentations, lifetime bans that they can never ever come back into the United States for misrepresenting or giving any false information to the USCIS or the CBP or the consulate in obtaining any immigration benefits. That's a major thing. A lot of these things happen because of the misconception people have. We have seen a lot of people who are getting deported in the airport, Emily, especially when they have no clear idea where exactly their job is, what job they are going to do it. In the H-1B filings, though, they do say that they are going to file in the in-house, but they know they are not going to work in the in-house. They have no idea where they're going to work at. When they come into the United States, they're entering it with that H-1B, which says in-house project, but there is no in-house project. These people are getting barred forever for misrepresentation. We're also noticing for multiple filings of the H-1B, when people are going for stampings, they are getting a lifetime ban to ever not come back into the United States. A lot of 221Gs right now. Now, people need to understand when you are coming into the United States on an H-1B, you must have a job in hand for you to work. And that job must have an H-1B approval for that particular job. For example, if your company is going to employ you at, let's say, Coca-Cola company, do they have a H-1B approval? Did they mention Coca-Cola address? Did you mention where you're going to be staying at? There's a lot of misconception about it. Because of the misconception people are. If people get aware, you just look into the H-1B petition. Have your company send an H-1B petition. There are three main important things that you need to look into. First is the employer letter. It's about 2 to 4 pages employer letter. Read it. Most of them is not, it's about the company information, job information, but at the same time, there's also information, who's your end client, where you are going to work at, what is your job title. All those things are very important. And also there's a document called I-129. Look into it. What is your salary? Where are they telling that you're going to be working at? And also an LCA, labor condition application. You need to look into it. Where does it say that you're going to be employed at? If you are knowledgeable with these three documents, though, you will have a very easy time entering into United States. But if you have any doubts about this employer letter, I-129, or the LCA, it's better to speak with your employer, or if it is better to speak with a lawyer to make sure you're on the same page. Because the CBP will look into those documents and will ask questions about it. And if you're not aware of the position, if you're not aware where you're going to work at, they're going to send you back. You don't even know where you're going to work in the United States, and you're coming into the United States, they're going to send you back. And if you don't have a job in the United States, you're coming on H-1B, they will send you back. Recently, we have seen an uptick on the people who have been deported who are coming on H-1B. So please be aware of it. And when people are going to the consulate, though, the same three documents are very important. Read them very carefully. If you have any doubts, speak with your employer, speak with your lawyer, so that you are on the same page. Because when you're telling a different story and the employer is telling a different story, then there's a big mismatch. Employer is telling a job is in Atlanta, you're telling the job is in Chicago. That's a complete mismatch. So they will deny your H-1B, and sometimes if there is a major cause, they may even bar you forever coming into the United States. So please be aware of these three documents. Emily, go ahead. Any recent data that you have on these deportations?
Yeah, one of the other issues that we see come up quite a bit is when people are flying into the U.S. in one city that has no relevance to their job at all. Obviously, that's different from transferring flights to the end city. But let's say that your job is supposed to be in California, your company's in California, but you're flying into Michigan because you're going to visit your cousin first, or whatever the reason is, that's where you're going to stay. You need to make sure that you have a plan in place for when and how you're going to get to the actual job location. I think what we see a number of times is people don't actually have a job lined up yet, especially where it's a consulting company and there's supposed to be an end client, and they're told, oh, we'll just work on this in-house project and our company's in California, and then you just fly into wherever and have no plan for how you're going to get this end client, where you're going to be going to work. That's a problem as well. So you need to plan your entry into the U.S. to make sure it makes sense where you're landing based on where your work is actually going to be.
Emily, layoffs are happening recently for some of the jobs. Now, I will give you a couple of different scenarios. Tell me, everybody knows that when the H-1B person get laid off, and if their I-94 is still valid, they get 60 days of grace period in which they can either choose to go to another company, choose to go to B2, file a compelling circumstances CAD, and if they're eligible for H4, they can apply for H4, and some of the people may even apply for F1 in that 60 days period. The main question that comes up with the people is that when does the 60-day period starts? Let's say, for example, I'm working for Coca-Cola company, and the last day of employment with Coca-Cola company is December 15th. That means that my laptop and everything, I have to give it up to them. However, they are going to pay me the paycheck until February 15th. When does my 60 days start? December 15th or February 15th?
I think it depends. Always the lawyerly answer. It really depends on the pay statement and how it's going to appear. So if you are going to be continued to be paid on your regular payroll and there's nothing mentioned about a termination date or severance pay or anything like that, USCIS typically will look at when did you get your last paycheck, and that's what they use to calculate whether you filed within the 60-day grace period, unless the company has actually sent notification to USCIS before that, because most of the time the company is supposed to withdraw an approved H-1B when the job is no longer there. So if it's regular payroll continuing to February 15th, I've generally not had a problem in filing with the grace period from February 15th to April 15th. But if that paycheck after December 15th now says severance pay, and maybe it's a different amount, or the taxes are being taken out differently, or it doesn't show all the same data that your previous pay statements have, then we need to go based on the December 15th as your 60-day grace period start date.
Okay, and then typically if the payroll is normal February 15th, you didn't have any denials, did you? When you filed, means in April of 2000, before April 10th of 2000, and after 60 days, you didn't have any problem. Okay.
Yeah, really, when I'm filing a transfer, I don't even ask generally the employee, hey, when was your last day of employment, if I know that they're not working anymore. I just look to see if the pay stubs are within the last 60 days, and I file it. I don't think I've ever, since this rule came out in 2017, never had any issues with that, as long as the pay statements are there and they're regular payroll.
Let me tell you the scenario of remote working, Emily. My H-1B is from California. I moved, and my company is in California, San Jose, California. And I'm working from home. I'm not working from the office. Can I not work from Dallas, Texas?
No. Even though your H-1B may be approved for you to work from home, it is still location specific, because the salary requirement, the prevailing wage, is based on your physical work location. And so even if you're doing the exact same job, if you're doing it from San Jose versus doing it from Dallas, those are going to have two different prevailing wage requirements, and the company needs to be in compliance with that.
Emily, the salary requirements of San Jose is more than Dallas. Why do you have a problem?
Because DOL has a problem. They basically say anytime there's a material change in employment, an amendment has to be filed before that change can take place. And on top of that, USCIS has said that they consider a material change in employment anytime a new LCA is required. And whenever you change work locations, if it's outside the metropolitan statistical area where your LCA is certified for, that is a requirement for the company to get a new LCA. The requirement of getting that new LCA triggers the requirement of an amendment. So regardless of whether the wages actually, the prevailing wage actually goes down because of your new location, the requirement to get the new LCA is a DOL requirement, and that triggers the requirement to file an amendment.
A lot of people ask me this question in the particular community that I go in. Oh, how do they come to know? Mm-hmm. Guys, you guys are IT professionals. You are writing these programs. They will know. Maybe they're tracking your cell phone. I don't know. The driving license has changed to Texas. You bought a house in Texas. You left the lease in San Jose. You have insurance in here. You're visiting doctors here. There are many ways that the USCIS will come to know. And out of all, hey, the FDNS may come and visit your apartment there or your office and ask the simple question, where is this guy? Okay? Your paycheck might tell you you're from Dallas. So please don't ask me this question. How does the USCIS come to know? You are at least 95% of the people who are listening to this one are software professionals. You guys do the programming for the companies, for your own companies. USCIS does it too. They take the help of third-party people. They do their own investigations. They know it where you are. all tracking difference there. But of all, they can just ask you a simple question, where are you? And then you have to answer straightly. And Emily, I have found some dumb guys answering the wrong question, wrong way. Even though they were in Dallas, they tried to bluff the USCIS FDNS and got into bigger trouble where they got their lifetime ban because of misrepresenting and telling the FDNS officer wrongly.
Yeah. So they think that, oh, if I don't change my address on my payroll and I don't change my address on my bank account and I'm staying with a friend, that it doesn't count somehow. And they can tell USCIS that they've been working from the other location this whole time because on paper, that's what it looks like. That is not true. Do not do that. You cannot lie to a USCIS officer. That is a clear big violation. That's what's going to get you banned. You're going to have all kinds of trouble from that, and they know. They can figure it out.
And guys, if you're ever been cornered where you have to answer the question though, especially with the FDNS, take a time out. Tell them I want to speak with my lawyer before I speak with you. With FDNS, you have the authority. Okay, but if ever you are cornered in some other location where you don't have an option. Now, fraud detection unit, you have an option. You clearly said that I want to speak with my lawyer before answering the question. If ever you're working in Dallas, your LCA location is in California, you don't want to answer the question at all, you time out. Tell them that I want to speak with my lawyer. If they say no, then you say that my lawyer told me that without speaking with you, I cannot answer the question. Now, in certain situations, for example, at the port of entry, you may not have that right though. In that position though, if you are in that position where don't tell a lie, tell the truth, the punishment will be way, way less than telling a lie. So if you're cornered, either tell the truth or don't tell anything. Let's go to the questions, Emily.
Yeah, on that topic, Vishnu had a question. If I always work remote, when I'm at CBP at the port of entry, how do I answer the question, what's your work address? And in his case, his LCA does mention his home address as a secondary place of employment. So on all of the petitions I file that where the person is working from home, on the I-129 form, page 5, work location address, I list the employee's address and I specify that this is their residence. I put that same address on the LCA, and in the employer letter of support, I say the person is working from their residence in whatever location. So when you're going into CBP, it's fine to say the same thing. I work from home in whatever city and state. And if they ask more questions, you can say my company is located in this location, my end client's located in this location, but I work from home in this other location. But you need to make sure that your documentation reflects that as well.
My wife, Arun Patel, has this question. We're going to go to question and answer. Arun Patel has this question. My wife is a doctor working for a university and cap exempt H-1B as a professor. She's teaching undergraduate students for 2 years now. Can we know how we can apply in EB1 category? Arun, there are 2 categories though your wife may be eligible for. One is EB1A category, but there is also one thing called EB1B category. For the EB1B category though, only the university can file it. Your wife cannot file by herself though. If the university is willing to file, sometimes they may require your wife position to be a tenured or going to be tenured position. If that is true, then they can file the EB2 application. They can file the, not EB2, EB1B. EB1B is more easier, but it has to be filed by the employer. There are certain requirements. Normally, with a university and a doctorate, if they are going to be willing to find, it's a slam dunk, guys. That's so easy to get in. Now, of course, if the employer is not willing to, you can consider filing an EB1A category where your wife doesn't need your employer to sign any document. She can file an I-140 signed by herself and file the EB1A category. You should consider in both categories. Emily, is multiple filing banned this year? Can you explain what the USCIS is trying to do? This question is coming from Surendra Gotipati.
So they have proposed a regulation where if you have 10 different employers that submit your name 10 different times and you get selected 10 different times, you choose one of those 10 companies to go forward with. So you basically only get your name put in the hat one time, even though you've submitted 10 times. So you get no benefit from these multiple registrations. That's the proposed regulation. It has not been published as a final regulation yet. Separately from that, we have this new potential online filing system for the I-129 form, which is the H-1B petition. And we think it also is going to include the lottery. But I don't think that by itself eliminates the duplicate filing. So I think we have to wait and see if USCIS is going to publish this regulation. I don't think they can at this point because they typically requires some advance notice, and we're getting awfully close to not having enough time for that advance notice. So that being said, duplicate filing, don't do it, because we saw what happened last year. USCIS is cracking down on that. They're continuing to send notice of intent to deny, notice of intent to revoke. People are having trouble getting their visa stamp. People are getting deported at the airport. People are getting their transfers, notice of intent to deny, their extension with another company, even 3-4 years after the fact. So USCIS is definitely monitoring that. But is it actually banned yet? I don't think so.
Ashish has some interesting statistics, though. He's telling that recently the approved I-140s in the 6 months have gone from 482 to 680K, the people who are waiting for the green card. In that particular thing, he says the EB1 has jumped from 7,000 to 80,000.
Yes.
I don't, is that true, Emily? I mean,
it is true, but the reason for that is the retrogression in EB1. So all of those people that, because this cuts off September 2023, right? So before that, we had all of these people who had approved EB1 I-140s who had a current priority date. And then all of a sudden they moved the date back to what, I don't even know, 2012? Not 2012, but back many, many years for that 1 month. And that's when they took the data. So that all these people who were current before now retrogressed. Now we've got all these approved petitions that are backlogged. But if we fast forward to today, the date moved forward again. So it'll correct itself the next time around.
But one problem I have with what Ashish is saying, and I think so what you're telling, Emily, is that if what you're telling is that on September 2023, they backtracked it and all the pending applications are showing in the 80K. Okay.
Yeah.
But the rest of the world has not been backtracked. It's only the Indian nationals and Chinese nationals who have been backtracked. Let me check into that. So that's going to be October. So only the Indian nationals and Chinese nationals are backtracked. Let me check into that one more time. Yeah, only Indian nationals and Chinese nationals are backtracked. So practically, if 80,000 people that their priority date is not current in October, Emily, then all these 80,000 must belong to Indian nationals or Chinese nationals, though, which actually may only be backlogged not by many years, because it may backlog a lot more years just for EB1, Emily. That's right. He's right.
Yeah. I mean, it was in September 2023, it was backlogged to January 2012. So that's 10 years worth of EB1 India approved I-140 petitions. So if they're approving 7,000 a year, that becomes 70,000.
Yeah,
so
they backtracked all other nations also. I'm sorry, I take back. On September, they backtracked EB1 for all other nations also.
By 1 month for everybody else.
By 1 month, which is not good. Which is not big. Okay. But still 80,000 is a big number, assuming that
But over
certain
10
number of
years, though, that represents 10 years.
10 years of Indian nationals.
Yeah.
So technically, when we spoke with Charlie Oppenheim last week, he was on this show. He did said that EB1 is expected to be backlogged, so it's not going to be moving that fast. So based on what Ashish is telling and what you have read and what Charlie has said, yeah, it's going to be a significant backlog in EB1 and very slight movement for EB2 and EB3 going forward in the next couple of years.
Yeah, I think he indicated it could be 7 years before EB2 gets to January 2015, which we've kind of been suggesting that.
Yeah.
Because of the per country limit. Let's see here. Eubene says, my I-485, 765, and 131 are pending. Can I accept a promotion from software engineering team lead to software engineering manager? Most likely. So number one, we need to see if you qualify for AC-21. That means, is your 485 pending for at least 180 days? In that situation, you are eligible to take another job offer, even with the same employer, as long as it is in a same or similar occupation. And with AC-21, USCIS has come out and said they recognize that people are going to be promoted over time. And so they do take that into account when they're trying to determine what is same or similar. So typically, I've not had any problem using AC-21 for someone to make this kind of promotion. But if you haven't hit 180 days yet of your 485 pending, you may need to delay that to avoid any issues.
My LCA as my old home address, and I moved within the same MSA working from home. Do I need an amendment? This is from Ram Kumar coming from YouTube. What he meant to say is that he moved within a very short distance from his home. There are certain definitions of MSA. If people know, that's fine. If not, if within short distance. Let's say, for example, 20 miles within the home address. Does he need an amendment? Absolutely not. If you are doing the same job, same end client, similar job duties, you don't need an amendment. If the FDNS comes in, they find out that you changed the address with all the techniques, which I told before, you will not have any problem. It's only the people who move out of the MSA. That's the people that needs to file an amendment, not after they move, but before they move.
Ankit says he had won the diversity lottery back in 2020, submitted the DS-260 at the consulate to begin that consular processing process, but then never went for the interview. He was later denied a B1, B2 visitor visa because of immigrant intent and wants to know, how can I overcome this? So having that DS-260 filed is one factor that they look at, because in the DS-160, which you would have submitted for your B1, B2 visa interview application, you would have had to disclose that you previously applied for an immigrant visa application at the consulate. So you have to check yes to that, and you can explain that it was in 2020 and you never went forward with the interview. So that's kind of the starting point for them. So now it's, what other factors can you provide to overcome that? So they're going to be looking at, what are your ties to your home country? Do you have a job there that you've worked for years and that employer has given you an employment verification letter confirming that, and confirming that they're allowing you to take 2 weeks off to go to the United States to visit for your brother's wedding or whatever the issue is. So that's one thing. Do you have the job? Do you have property there? You need to show that you have, you own property there, and that's going to be the reason why you're going to come back after this short visit. What's the purpose of your trip? How long do you plan to stay? Is that reasonable for what you're trying to accomplish? And do they believe you in all of these things that you're saying? Do you have family back home that's going to keep you from coming home? Is your spouse going to stay home? So obviously you're not going to abandon your spouse in your home country? Are there other people in your family that are in your home country? Or is your entire family in the US and they're all US citizens? That could be a problem. So it's those are the kind of things that they're going to be looking at, in addition to just the simple fact that you had filed a DS-260 previously. And yeah, you're going to bring documentation of all these things to the interview, but documents are going to be secondary. It's all about you answering their questions. Do you come across as credible? Does the consular officer believe you? Is what you're saying reasonable? Or is it in line with the purpose of the visa that you're applying for? So you need to be really cognizant about the interview itself and be prepared for that, and not rely so heavily on documents.
Emily, I have three topics, and I feel that all are important, but I also need your input in these three topics. I want you to pay attention to what I'm telling, and please correct me and suggest your own interpretations of what I'm interpreting. Ramjan Ali has this question: what are the things, what will take the H-1B person who is entering into the United States, go to the secondary inspection, the person who's coming on H-1B? It could be random, which I'm very surprised, which they say it's random. There can be some tracking of you. Either they might have tracked that you may have used a resume at the time when you got the initial job. You may have told that you have 6 years experience when you don't have it, and you got the job and they have that information. This is the most common reason we see people getting denied entry into United States. Out of all the reasons, this is the most common reason for the H-1B that we see. Second thing is that they might have got, like you are working in Chicago, Illinois, and your H-1B is from California. You're landing in Chicago airport and telling them, no, you're actually in California, you're going to move to California while your driving license, your paycheck, every statement says that you are in Chicago, though. That could be one of the reasons. There may be some other reasons that sometimes tell some of the reasons, Emily, that what you have noticed. The first reason is the plagiarism.
Based on information in your DS-160, which you filled out to get that visa stamp. Maybe you mentioned employment with a company that has a bad reputation, like Integra or AZTech or one of those companies. Maybe you attended a day one CPT not so good school and didn't mention it on your DS-160. They know you've attended there. You had the F1. They have all of your SEVIS records. But why didn't you put that on your DS-160? So those are also issues when there's a discrepancy. Either you're leaving information off that they know about, or you're providing the information, which you're required to do, but it's showing that, hey, there might be a problem here because this person was affiliated with this company that we know was doing bad things.
Oh, I forgot the main other reason. The second main other reason is that you are going to work in an internal project for a consulting company. And according to the records, they probably have 25 or 100 H-1Bs on an internal project. And they actually only have PO box there and no internal project. When you Google them, that company address is just a PO box. It's very surprising we see that. So whenever you are coming, just Google the company name, Google the address. What are the addresses who are there in that particular thing? Is it a virtual address? Please check those things too. These are the common reasons we see. There are sometimes very rare reasons we see for the H-1Bs. I'm only addressing the H-1Bs right now. Anything else, Emily? But before I move into the second topic, which you already touched a little bit. This question comes from Rig Veda from Twitter. Are the day one CPT universities, is the day one CPT legal? Are the day one CPT universities legit? Should we go and join the day one CPT university?
Yes. We've long said that these are not good schools. These are not, I think they're not following the law. Has USCIS decided yet that they're not following the law? Maybe not, but maybe they're gathering information. We've had so many other schools that they use to track people. Yes.
Well, it's an accredited university. What do you say about it? Why did the US government accredit it if it's not a legit school?
There are how many thousands of universities that are approved to issue I-20s in the SEVIS system? How many thousands of those universities also offer day one CPT?
4.
Yeah, that's got to tell you something. If University of Michigan doesn't do it, if University of Texas doesn't do it, if UCLA doesn't do it, all of the
doesn't do it. Texas A&M doesn't do it. University of California doesn't do it. University of Florida doesn't do it. And why only 4 universities do it? Yep. Please, if something walks like a duck, talks like a duck, probably it's a duck, guys. There are, as Emily has pointed out, there are 3,000 universities or educational institutions. Only 4 institutions are very famous in issuing. And before Emily, there were 4 other institutions, though, before these 4 institutions. Memory is very short for a lot of people. But for us, it's very long. We have gone through the experience. I will tell you the 4 other universities that were there. Silicon Valley, other than these 4 universities, there is called Silicon Valley University. You know what happened to their all the people who worked in the higher authorities of Silicon Valley University? They are in jail. Let me speak with my Indian people in their language. They are in the Sri Krishna Janmasthan. They will understand what that means. Okay, second, there is called Tri-Valley University that used to issue day one CPTs. Emily, where are they right now? The presidents and what about the higher authorities of Tri-Valley University?
Yeah, they're all in jail.
Okay, and there are 2 other universities. The so-called presidents are not in jail, and they have issued day one CPTs, and I want you to explain about those 2 universities. One is University of Northern New Jersey and Farmington University. None of those authorities are in jail. Explain that.
Yeah, because those were universities set up by ICE to get the students who were doing this because they know it's wrong. So they created fake schools, fake everything. They had recruiters reaching out to students saying, hey, come join our school. We'll give you day one CPT. We'll do pay to play. You can keep working at your job. You don't have to ever go to class. This is great. And people agreed to it. They never thought, hey, maybe there's a problem here. And so they enrolled in it. Never went to class. They told they're accredited,
Emily. They told they're approved.
Mm-hmm. Yep. And so it was a giant sting operation, both universities. There's only a matter of time before something happens with these 4 universities.
So think of this, guys, because there are a lot of sting operations that happen in USA. But do anybody come and tell you that they are going to sell a Coca-Cola bottle, and then if you buy the Coca-Cola bottle, will they take you inside? No, they never sell Coca-Cola bottle. They only try to tell you that they're selling you some heroin or some Coke, the Coke that comes from Colombia, not the Coca-Cola, that the bad thing that comes in, and they will tell you, they will sting operation. So these 2 sting operations that happened were day one CPT university. That should tell you whether the day one CPT universities are legitimate or not. As Emily pointed out, 2,996 genuine universities do not give day one CPTs. And when people get caught, people get in trouble, people get deported, people get their H-1B rejected, people get their visa denied because working in the day one CPT, people get their port of entry denied. They come to us with some question. They said that they are legitimate. Well, everybody says it. Does the thief tell you, in front of everybody, I am a thief? They won't tell it. You have to find it. Caveat emptor, we call it in Latin language. So you need to find out the characteristics of it. The characteristics of this fraud university is that the admission is at any point of time. When does the college start? This is what they say, whenever you want to. Really? Normal university, 2,996 universities will say it's December, January, August, September, something like that. These people will start. Admission is free, open. Anybody can get into admission. You just apply, you get it. There is no rejection at all. You don't have to go to school except for 6 days in the entire year. Okay. And now they have even created the branch office assembly in different cities. Oh, you don't have to go to Missouri or Kansas. We're going to put you in Dallas. Those live classes in Dallas. And they have made all these different provisions to lure the people to get them pay the money without attending the classes and getting the day one CPT. So these are all signs of not of trouble for you to go into day one CPT. Are we done, Emily? I have one other topic that I want to discuss with you. This question comes from Akhil. It's a very interesting question. He has an I-140 approval. How to get the H4 and H4 EAD approval faster for his spouse? Now, there are a couple of different ways that I will tell you, and anything missing, or please cover me up because I always miss something. One thing is that when you file a H-1B extension, if you file H4 and EAD together, and you file H-1B in premium processing, all three will be approved at the same time. That's one way of getting it faster. Well, my H-1B is not expiring for the next 2.5 years. How can I extend it? Well, you can file an amendment plus extension. You don't have to give any reasons to file an amendment. You can file an amendment plus extension and file for the H4 and EAD at the same time. You will get the approval along with the premium processing. Now, this is for the initial H4 applications, though. For the extensions, though, there are some times where the company files the H-1B and they refuse to file the H-4 and EAD together with the H-1B. In that case, what we tell is that let the H-1B get approved. You file for the H-4 plus EAD, assuming that your H-4 I-94 is still valid. This is only for extension, guys, not for the initial H-4 EAD. You can go to Mexico and you can come back, use your spouse's H-1B approval to extend the H-4 up to the time your spouse's H-1B is expiring. Since you already filed the H-4 plus EAD extension, the law allows that even if the EAD has expired, and if you get the new I-94 when you come back from Mexico, you're allowed to work up to 180 days after the EAD is expired. Any other things that I missed, Emily? Or any
Yeah, so let's say I'm doing this Mexico option. My spouse got their H-1B extension approved really early. They filed it at the 6-month mark in premium processing. My H-4 is expiring in a month or so. So I'm traveling to Mexico. When I come back in, do I tell the officer, yeah, I'm here to extend my I-94? Is that going to work?
They may call that as it's not a meaningful entry. I would always tell them, I just went to Mexico to have a margarita. I'm hoping that you do drink margarita. If not, the Mexican coffee is very good, guys, especially in Cancun. On the street side, coffee is the best. I always will tell I went there to have a margarita. Nothing wrong with it. And
yeah,
then make sure that you...
The problem I see is when people come back saying that my trip was, I'm asking for an H-4 extension here at the port of entry. They're going to say, we don't give H-4 extensions. You need to file with USCIS. You need to say, I'm coming back to join my husband who's on H-1B. Here's his H-1B approval. Here's my H-4 visa stamp. And let them issue the I-94 to match the H-1B approval. But if you tell them that you're here to get your H-4 extended, they're going to tell you, you need to file that with USCIS. I've seen that a number of times.
Yeah, the language is very important, guys. They want a meaningful departure to go to Mexico. So that's the reason I always say margarita, please. There's a meaning behind it. Why I call it as a margarita switch. I'm done with my 3 main questions, Emily.
All right, back to some YouTube questions here. The MS Paresh says, I have a GC interview coming up for EB3. My perm shows my job is located in the company's office in Ohio. There's no mention of telecommuting on the perm, but I actually work from home in Ohio in the same MSA. Will it be an issue if I mention work from home as my GC work location? Well, you have to first realize that your current job may be different from the job that you were sponsored for the green card. Your current job allows you to work from home. Your job that you were sponsored for the green card is the future job you will move into, because it's a permanent position that you get when your green card is approved. So if you intend to go into work into the office when you get your green card, that's what you need to explain to the officer, is that I will be working in the office. That's part one. Part two, if your job has actually moved to where you're working from home, then we look at, has your 485 been pending for at least 180 days so that you qualify for AC-21. AC-21 allows you to accept a job offer that as long as it's in the same or similar occupation. So I'm assuming your occupation is the same. The only difference is your work location. So you qualify for AC-21. You could have your employer provide a 485 supplement J, providing this updated work location. So that would be another way to handle that situation.
Juhuisa has a good question. If USCIS has done so many sting operations for day one CPT, why can't they do it for duplicate filings of H-1B? Well, they don't need to do it. They already did it. They published it, Juhi, online, that 400,000 people have filed for the duplicate applications. And they are acting on it, Juhi. They are acting on it. All those people who have filed the multiple applications, please be aware, they're hitting slowly and slowly. First, they're going with the big fish. They're coming to the small fish as gradually they are going. They are hitting them because they don't need to do sting operations, because if the person has filed for a duplicate application, it's there in their file. They can see John Doe, date of birth July 3rd, 1994, has filed 2 applications. It's there. They don't have to do sting operations. It's like going after the drug dealers. They don't have to do it. They are coming here and registering themselves online. So it's easy to catch them, and they are catching it. However, there are so many people for them. They are going for the big fishes. They're coming to the small fishes as gradually they go on. So we don't see all the revocations happening immediately when they file it. They are doing it gradually. They don't have manpower to handle them. They are doing it gradually. They are going to eliminate most of them, if not all of those people.
Krishna says, my I-140 got approved in October, and then the company got acquired by another company. He wants to know if the I-140 is not withdrawn or revoked, can I still use that approval after 180 days to file my H-1B extension? Yes, even though it has the old company's name on it and that company no longer exists, as long as the I-140 has remained approved for 180 days, you can keep using it to extend your H-1B beyond the 6-year limit with that company or any other company.
Ghana has this question. She got laid off last month. The employer wants to continue on a contractor for a few months. Can I work on 1099 with them? Technically, they will still be holding my H-1B. The answer, Ghana, is no. You cannot work on 1099 on a H-1B.
Pooja says, can I continue to work if EAD and H-4 extension are being processed? Not just based on the pending extensions. As Rahul mentioned previously, in order to get that auto extension of 180 days, you need to have the extended H-4. So if you have the H-4 already extended and then you have the EAD renewal in process, then you can work based on the pending EAD. But if your H-4 has not been extended yet, you have to stop working when your EAD expires. So that's where that margarita in Mexico can come in handy if your spouse's H-1B extension has already been approved, so you can get your H-4 extended at the port of entry and then you qualify.
Manoj Kumar has an interesting question. It relates personally to me. Can my wife use green card EAD even if I still continue working on the H-1B? The answer is simply yes. And I did it. My wife was an H-1B, I was an H-4, I got the GCEAD, my wife was still working on H-1B, I started working on a GCEAD. I started working as an immigration lawyer. I started going to the immigration interviews. The first client of me, I was working for a law firm, asked me the question, Rahul, when did you get the green card? I didn't say it to him because if I tell him, I went for the GC interview for him. If I tell him I'm an EAD, he will run away 100 miles from me. So I told him, wait, I will tell you afterwards. Of course, the interview was over. He got the green card. We went out. He took me the Red Lobster. That's very nice. He was very happy. And then he asked me a question. Why didn't you answer the question? Oh, I don't have the green card. I'm working on the GCEAD. My wife is still working on H-1B. Like, what? Yeah, your wife can work on GCEAD and you can continue working on H-1B. Absolutely not a problem.
Vishwas says, when a person on H-1B is awaiting their extension, but they need to travel due to an emergency, what are their options? So you can leave the U.S. while your extension is pending. It'll still be processed. So leaving is not the problem. The question becomes, how do I get back? And that depends on whether your current H-1B has already expired when you're ready to come back. Then you have to wait for your extension to be approved. Then you have to get the visa stamp, and then you come back. But if the extension is pending and your current H-1B has not yet expired and you already have that visa stamp, you can go and come back on your existing H-1B. The extension's not going to have any issues. As long as you are in the country filed, you can leave while it's pending. It can create some funny things with I-94 numbers. So you can speak with an immigration attorney about that to make sure that's taken care of if you come back while it's still pending.
Satish has this question. Can my wife work on, his wife is on H-4 EAD. She started her own company. Can she be the first employee of the company? Absolutely. She is the entrepreneur. We salute the entrepreneurs. We need them. That's very good. She can be the first employee. Why not? There are a lot of people. Michael Dell was there. Microsoft CEO, not a CEO, Bill Gates was the first employee. For the Apple, Steve Jobs was the first employee. Hopefully your wife will be listed along with them. Absolutely nothing wrong with it. The question that comes about TikTok, since it's a Chinese company, will it have any problem if my friend gets an offer and accepts it? No. TikTok is also registered in USA as a company legally. Whatever restrictions are there does not exist when you are working with TikTok. There are some restrictions in India, though. But as far as the US is concerned, though, TikTok is legal and working for TikTok is legal. They already filed almost 800 H-1Bs right now, legally working, and no problems with any of those people moving from TikTok to other company too. No problems.
Dhruv asks, have you heard any news on the Dropbox rule changes asking for people who applied in 2023 but have their interview scheduled in 2024? Yeah, I had this come up just over the weekend. So I have someone who submitted their DS-160, booked all of their Dropbox everything in 2023, went to drop off their documents in 2024 and was given a 221G because they no longer qualified for Dropbox because their last visa was issued more than 4 years ago. So if you're in that situation, when you go for your Dropbox, based on my recent case, it appears that they'll give you a 221G telling you to come in for an in-person interview because you no longer meet the Dropbox qualifications.
Anything else, Emily?
It looks like we are out of time for this week. I want to remind people that if you are interested in EB-5, if you want to learn about it, not sure about it, want to take advantage of the fact that EB-5 is the only category that's current right now in the visa bulletin for those born in India. We have set up a special website for you. You can go to rnlawgroup.com/EB5, enter just very basic information, and you'll receive information from us. You'll have the opportunity to set up a one-on-one consultation for free to learn about what it is and whether you might qualify for it, whether it's something that might be beneficial to you. We also have a WhatsApp group that you'll be invited to, so you can ask your questions there. So I definitely recommend for you to check that out. It's rnlawgroup.com/EB5.
I put the link out down there, guys, for you, for easily at the bottom of the video. Thank you very much.
Thanks for joining.